Welcome to All Things Work. I'm your host, Anne Sparaco. Today, we are exploring how you can prevent misuse and abuse of the Family Medical Leave Act and deciphering ambiguities in connection to related laws. Now, it might seem like a daunting topic for some, but here to guide us is Abigail O'Connell and Marjory Robertson, who are experts in absence management as senior counsel for Sun Life Financial. Welcome, Marjory and Abigail, to All Things Work.
Thank you very much.
So can you talk about your roles a little bit and what your roles entail?
I'll start. I've been at Sun Life longer than Abby, so I can talk. I like to say I've been here 100 years, but that's stubborn my sense of humor. I'm Sun Life's employment attorney. That has been my day job and continues to be. So I advise Sun Life on our unemployment issues. But in the last several years, we've started offering outsourced absence management to clients. So that's been very fun for me. And I've helped design our accommodation services and I provide guidance. You will hear that I love accommodation issues, ADA, PWFA. Abby loves the FMLA, but I'll let her tell you that.
I'm Abigail O'Connell, and I've been at Sun Life for nearly 7 years, but not 100 years. So, yeah, sure. And I work exclusively on our leave management products. So we do absence outsourcing for the Federal Family Medical Leave Act and other state laws. And we also have a paid family medical leave product because those mandates are becoming more and more popular. And so I'm very passionate about leave. I think paid leave in particular is going to help close the gender wage gap. And I'm excited to be here today and speak with you.
Love it. We're so excited to have you both. And you talked about yourselves as enthusiasts in these different areas of this topic and, just fascinated by the topic itself. So, Abigail, let's start with you. What drives your passion behind absence management?
So I've worked in the industry for about 20 years, and I think my passion for absence really grew when I became a parent myself and understanding the need to be able to take a job protected leave from work, particularly like to take care of a family member or your own health condition or bond with a new child, and then be able to have the ability to walk back into your job that started prior to your leave. So I also really love the sticky issues on this and sort of helping reach consensus between employees and employers. And I think intermittent leave and leave abuse are all topics we're probably going to get into today, which, really drive some of those stickier issues.
And Margie, what about you?
So I'm a true nerd. I have no life other than the law, but I couldn't do any type of law. The accommodations, issues I find really intriguing. They're all about fairness and reasonableness, and they don't have as many rules as the FMLA, so I enjoy that. I really enjoy helping employers grapple with tough issues, and I have an employee bias. And so I feel like I'm doing good because my focus with employers tends to be on helping them avoid lawsuits. And the main way they do that is by being nice human beings.
I love that. Yeah, and I'm sure your clients are very grateful for that nerdiness behind it all because it means you're passionate, both of you, and it shows that you really care and put your heart in the work that you do day in and day out. And that's why it's so important for you guys to be here talking about this because you're going to be able to help guide a lot of people in our audience today. And so I would love to kind of dig into what misuse and abuse of FMLA can sometimes look like. So what are some of those common scenarios, that people can kind of picture to get an idea of what it looks like?
So I'll dive right in level set that I don't think FMLA abuse or misuse is common. I know that there are employers who face challenges, but as just a general principle, I really don't think people are getting certifications and falsifying leave to take unpaid leave from work. I think the vast majority of employees take this because they need it. And then I guess I'll kick it over to Marge to highlight some of the top level signs of abuse.
Yeah, although you're going to hear the same theme from me, which is that I advise our own HR people and managers all the time. And when they start suspecting abuse, I say, whoa, because that's a very high risk accusation. The problem with the employment laws, or I don't know if it's a problem, but one of the facts of the employment laws in the US is you can end up with a jury trial where juries can award millions of dollars in damages. And those cases are often won or lost on who's the least offensive or who's the good guy. And so managers, very risky to start accusing people of abuse. And there are ways that you can tackle it, but not sort of headstrong as, oh, this employee. It's usually the employees they don't like, that we never like this. We're sure they're lying. And you have to kind of bring them back. Well, what happens? Why do you think there's abuse? And kind of walk them through it more slowly.
Right. Yeah, that makes sense. And, you don't want it to be common, and it's not common. So that's really good to know. And so in those, let's say, more rare situations where it does happen, what are some of the red flags employers could possibly see in that scenario?
I would offer that one red flag is medical terms that are spelled wrong, because that indicates to me that perhaps a healthcare provider didn't actually complete this certification wrong if they're spelling a medical term incorrectly. I think, another sign I have seen is a single provider writing out a large number of employees from one employer population. And then I guess a third sign, and I would stress that I have seen these rarely over my career, but a third sign may be that you have employees who are relatives of each other consistently calling in the same days for leave. And there may be very valid reasons for all of these things to happen, right? Perhaps administrative assistant at the provider's office made a typo on the form. Perhaps the employees work in a rural population. There are very few providers, so you're going to see a provider writing out multiple employees. And in the last example, perhaps you have employees who are taking leave to care for the same family member. I would say for each act, you have to first give the person grace to say, is there a valid reason why we're seeing this before pressing further?
Right. Marjorie, I love that you said, kind of given the benefit of the doubt, don't jump to conclusions right away. It's the art of patience and trying to think moving forward. So Marjorie, do you have anything to add to that specifically?
So one thing that Abby participated in this for the first time this year, we required a second opinion and then a third opinion, which is something you can do under the FMLA. I had never done it. And it was actually quite effective. So I think sometimes where you get abused is where you have a doctor that will certify anything. And so we see this particular employee that we had to deal with, the doctor had certified intermittent leave, but up to 5 days per week. So that's a really intermittent leave. And he was having a lot of absences. And so we did a second opinion. And that process, I don't know that we want to spend a lot of time going into the details, but it's a crazy process. But it ended up working out really well for us because what you do is you get the second opinion, and then if the employee doesn't agree with that, which in our case, we got a great second opinion, you then go to the third opinion, and then that's final. Whatever that third opinion says stands. So it's kind of a high risk, but it really ended up helping us in terms of once we got away from the employee's provider, we got much more realistic assessments of what absences were needed.
So do you have any other strategies or ways to remind organizations or employers on balancing the need to prevent FMLA misuse and also paying attention to the genuine needs of the employee?
So one of my main pieces of advice is to be patient. Don't fire somebody for the first thing. Make sure you give them warnings, that you try to understand why this is happening. And if it comes time to have a termination, I always hope that when the employee goes to the lawyer, and the employee shares what we've drafted, showing how kind we've been to them over time, that the lawyer will say, you don't have a very good case. And that has worked successfully for us, but it requires the managers to have some patience, which sometimes patience wears thin when you're dealing with FMLA abuse.
Yeah, and Marge, I would just piggyback that clear communications is so important. So if you want to have a discussion with your employee about a concern that you have, you're entitled to do that, and you got to do that carefully. And you have to, you've got to really have well-documented processes, particularly requiring certification when you can. That should be done universally, right? And not just for the employees you think are abusing leave. It should be for your whole population, and employees should know you have this much time to get this certification in. And there are reasons where it could be extended, that window of time. And that goes to Marge's patience, right? Don't, on day 15, when you don't get it, terminate that employee. Leave space to have a conversation.
So in addition to policies and practices, medical certifications can also play a role in preventing FMLA abuse or misuse. So can you share why they are so important and the do's and don'ts to consider with them?
Do read the certification. When it comes in, it's on you. Your clock starts, right? You've got to make a decision in writing within 5 days. And it's going to be, I approve this, I deny this, or I'm going to cure for deficiency because the certification we received is insufficient or incomplete. So you lose a lot of options when you don't read the certification. Backing up to your question of why certify, I think it's just good practice. It's good organization, because if you don't certify, then I think you lose a lot of credibility when then you want to start certifying. So I think you just do it universally. And Marge, you can probably speak to that better about why you always want to certify when you can.
Yeah, I think certifications can be great. And Abby, the issue of read the certification, I think is hugely important, because sometimes the certifications can help you, because sometimes they don't say what it is the employee really wants. And so it's important to pay attention to the details in it. And then sometimes they're inconsistent. But you have one of the things about the FMLA, unlike the ADA, you have very short deadlines for dealing with things. So I think that you need to have whoever you have at your employer managing FMLA, they need to know what to look for and how to act quickly, but not in an offensive way, that's a carry state, but not in an offensive way.
Yeah, I think clear communication and documentation. And just as one example, if you have an employee who's requesting a continuous leave or as needed or up to 5 days a week, and you certify that and the certification supports 3 days per week, I think that's a great opportunity to have a conversation and level set with that employee to say, your provider's telling us you need 3 days a week. We know you asked for 5. We're going to approve 3. And then, and you always want to make your decisions in writing when you have them there. And you can point back to them for when that employee takes 5 days.
It takes a lot of training for HR teams and managers to handle such sensitive situations. Like Marjory said, you're walking this kind of tightrope. You're trying to, find that balance. You're trying to satisfy both sides, not be too, quick to judge or anything like that. So what advice do you have when it comes to that specific type of training for such a sensitive situation?
So I am a big believer that managers handling FMLA is a dangerous concept. I think, first of all, managers getting the information about the medical. There are cases that say that if a manager knows what somebody's medical condition is, that can in itself can lead to evidence of discrimination. So I encourage managers don't need to know the details. HR can know that, and they can hear the needs of the employee, but the manager the problem with managers is they think they're being nice. So they hear something about somebody's situation and it's very upsetting. So they want to let everybody know to be nice to this person because they're going through this and that. Well, that's a violation of both the ADA and the FMLA. So I think having a strong HR practice is great. We outsource. I think that outsourcing is a great vehicle for employers to help be compliant because we will be there. Abby or I will get on calls and we'll encourage people, employers, to approach things in a way that are less likely to lead to lawsuits.
Abigail, do you have anything to add to that?
Well, I just, to make the case for outsourcing, Marge had mentioned how she always advises against a manager getting that certification because that later could be used against the employer in litigation. And when you outsource, not even your HR team has that information, right? And so that puts a lot of distance between the employer and the employee in relation to the employer knowing the verified specifics of the employee's medical condition or their family member's medical condition.
Yeah, that's good to know. And so Abigail and Marjory, you guys both talked about your decades of experience in this type of work, and it's really impressive to learn about your background. And throughout your careers, you definitely probably learned a really valuable lesson when it comes to handling FMLA misuse cases. So what is one lesson each of you maybe learned throughout your time that organizations, really should be aware of?
I think there are ways for employers to get a handle on FMLA abuse without necessarily calling it abuse. And one of them, call-in procedures. The FMLA actually in the law itself, it says employers can have call-in procedures. And I find that those can help keep employees more honest. If they know that they have to call in and report the FMLA absence before. The other beauty of outsourcing is that you can require them to not only tell their manager before they're going to be absent, but they have to report it to the outsourced company, typically within 2 business days. A pattern I've seen is people who are abusing FMLA, you often don't hear the words FMLA until you're about to give them an attendance warning, and suddenly it's FMLA this, FMLA that. But if you have calling procedures and you enforce them, that gives an employer more leeway for taking disciplinary action.
I think my one lesson would be don't jump to conclusions, because a lot of times a coworker comes in and they say, Susan called out Friday, but she was running in a road race, and they show the social media and everyone melts down and freaks out and they pull the leave. And it's like, okay, well, Susan happened to post a picture from the turkey trot, which was 2 months ago. And that's what was on social media. So it's like, don't jump to conclusions, like investigate even what appears to be obvious misuse.
I think employees ratting out other employees is dangerous business.
I would say dangerous to say the least. This isn't related to anything I've ever done, but I definitely did hear of a story where, one person called out sick, and she said her boss saw that she was with family on the day she called out sick, and she called her out on it straight up. And so I was appalled to hear that. I was like, wow, that's not right. Me as, a non-HR professional, I was thinking, wait, there's something not right with that. That's not what that should be doing. So that's
And
interesting that you brought
it can
that up.
just to add to that, it can create if there is a lawsuit. If the manager has given the employee a hard time about an FMLA absence, that can serve as evidence of discriminatory intent that the manager resents them for taking too long. So it's you got to be very careful about the message you send. That's another thing that managers do sometimes is they'll talk in team meetings about how FMLA absences are so inconvenient and they're causing an undue hardship, which is true. Nobody's going to argue, but that's awful to say that. You can't, because that will intimidate people about taking FMLA leave. So
I think at the very least, everybody can admit, even for the employer, FMLA, having to go on leave is not convenient for anybody. A lot of people want to work. They don't want to have to take this time. Sometimes it's really for some serious personal reasons, and that's just not fun. So I would love to track back to, when we mentioned the ambiguity in certain laws, when things overlap, when they don't. So can you discuss a case, either one that played out publicly in the courts or one you've been more directly involved with, that requires anonymity, where the interplay between FMLA and another law created that ambiguity?
I think this is a great question because when I read cases, which I don't read nearly half as many as Marjory, but oftentimes you'll see the complaint starts with saying, well, this is an FMLA complaint, and this is a California family rights complaint, and this is in their 4 laws listed. And maybe the FMLA gets booted, right? Because maybe the leave is about taking time for a grandparent or grandchild, and it's covered under the state law, but not the FMLA. And so the lesson for me is you really got to think like, okay, why is this person asking to be out? If it's not an FMLA covered reason, is there another law that gives them a right to leave for this leave reason, right? If they're saying, I need to be out for this family member, but that's not a spouse, parent, child, and doesn't fit in locus, parentis, or adult child, does the state law cover leave for this person? And so to really evaluate it, to make sure you crossed like all your T's and dotted all your I's before you just denied a person leave. Because that's what I see in some of the case law is like it starts as FMLA and then it gets whittled down. Then there's a huge settlement under the state law claim.
Right. Yeah, I love how you're saying, even if this doesn't work, here's an alternative. There might be something else that could work for you. So I really love that. Marjory, do you have a case in mind that you could think of?
So I'm going to echo what Abby said. I think that employers have gotten better about understanding the ADA accommodation for disabilities, but we now have the Pregnant Workers Fairness Act, which is also an accommodation law. And they tend to forget that it's not just FMLA. So I deal with it with our own managers at Sun Life. We actually have a client who recently told us that all we offer is FMLA. If somebody can't come back after 12 weeks, we fire them. That's all we offer. And I that's not consistent with what the ADA requires or the Pregnant Workers Fairness Act. You have to evaluate whether additional leave is a reasonable accommodation. And a lot of employers just don't get that. Another area where I see employers getting tripped up is they think of workers' compensation as separate, but actually workers' compensation is just a benefit. It's not a leave, and they need to evaluate the request for the absence under both the FMLA and the accommodation laws. So I think employers really do have a hard time navigating all the different laws and requirements. And FMLA is so well known that they kind of get fixated on that. Actually, a lot more now. These new paid family and medical leaves, they go a lot longer than a lot of the FMLA leaves. And employers, it's hard to, not to fault employers, it's hard to keep up with, especially if you're a employer. It can be very hard to keep track of what the requirements are.
Yeah, so I'll add a little personal note to that. I've attended a couple of court proceedings where, the lawsuit entailed workers' compensation and just the argument, between the defendant and the plaintiff. It was just so fascinating to hear that in court. And I definitely got lost a few times, to say the very least. They used a lot of words that were very particular to workers' compensation. And I remember having to have the attorneys break it down detail by detail for me, just so I could really understand, what exactly just happened in court. So, to bring all these other laws into the conversation, I can imagine how much ambiguity there might be, where you really need to, like Abigail said, cross your T's, dot your I's. And Marjory, you talked about the Pregnant Workers Fairness Act, and as we understand, its final regulations went into effect back in June of last year, so making it a pretty new law.
I used to say, it's probably still true, that I am the person in the U.S. who's most in love with the Pregnant Workers Fairness Act. I think it's a great law. And it's the first really new employment law we've had at the federal level in years and years and years. And not only is it different from the FMLA, it's even different from the ADA. The main difference between the accommodation laws, ADA, PWFA, and the FMLA is that under the FMLA, if you meet the eligibility requirements, you're absolutely entitled to that leave. You get your med-cert in. It doesn't matter if it's inconvenient, doesn't matter if it causes an undue hardship. You are entitled to it, but it's only those 12 weeks or 26 weeks for one reason. In contrast, under the accommodation law, you have no actual entitlement, but the employer is legally required to do what's reasonable and to provide a reasonable accommodation. But the employer can point to, this is going to cause an undue hardship, or it's going to relieve you from an essential job function. But they have some more defenses that they can use than they do under the FMLA. And then the Pregnant Workers Fairness Act versus the ADA is different because the law itself took away one of an employer's defenses. So under the ADA, an employer does not have to allow an accommodation if it would relieve the employee from performing what's called an essential function of their job. So lifting is an essential function of your job. You have a bad back, you don't want to lift, you submit medical that says you shouldn't lift. An employer can say under the ADA, that's an essential function of your job. We don't have to accommodate that. The Pregnant Workers Service Act took that away. They said, as long as the employee will be able to perform the essential function in the reasonably near future, you have to accommodate unless you can show undue hardship. And that is a concept that employers really are not getting. And we haven't yet seen the cases draw. That's one thing about lawsuits is they have like these long lead time.
I would love to wrap up with what you both would like to leave our audience with, your final thoughts about this multifaceted topic, to help them move forward in this, like we said, a complex field.
So hearing Marge talk about the Pregnant Workers Fairness Act and all the lessons that we have yet to learn that we will learn, its law and future guidance, my message for our audience is follow the rules. FMLA. There's clear, bright line rules, right? So if you follow those rules, then you've got more time to devote to the messiness of accommodations and the interactive process, which you have a little bit of a less guardrails for.
My message is don't do it alone. I think that employment laws these days are so complicated that I don't know how employers, especially if you're a multi-state employer, I don't know how you're managing on your own. I think outsourcing, it's not, it may seem like a lot of money, but you're almost getting kind of free legal guidance, not free, but you do have outsourcers who will help you stay out of trouble.
Well, your passion, both of you, have made it such an easy journey to talk about, such a complex topic, really. And we appreciate your insights. So thank you so much, Abigail and Marjory, for joining us on All Things Work for this week's episode. And of course, we have new content each week with a newsletter and the latest research on these big topics. Just go to shrm.org/allthingswork. You can also follow us on social media, like, share, even comment. We want you to be part of the conversation. Thanks for joining us. We'll catch you next time.
SHRM.